Okay, we are back to our dealing just now. So basic concept of torrent system is where registration is everything. Okay, so all dealings in respect of the land must be registered. Okay, so all the charges, lease, which is more than 3 years, liens, okay, and easement must be registered. Okay, now the earliest Malaysian torrent enactment were based on the 1857 Real Property Act, which is South Australia, which was introduces torrent system. So we are following this. Now under this torrent system, the rule and regulation provided the basic structure for the registration of title. And then the validity of the transaction which are not registered will be denied. So basically, you must register. If you don't register, you will not be recognized. Okay. Now, indefeasibility becomes the feature of registration. Indefeasibility means no one can deny your rights to the land. You are the owner. Okay. Basically, nothing will actually jeopardize your ownership to the land if you are if your name is registered. Now torrent system has two main principles. We call it twin principle, so namely which is MERA Principle and Curtain Principle. So what is MERA Principle? So register book reflects all facts material to the registered owner's title, such as name, particulars of land, size of land, encumbrances. Okay, so all dealing transacted will appear in the register book. Information shall be deemed complete, accurate, and indefeasible. So whatever you do will be reflected in the register book. Okay, now for curtain principle, okay, now for intended purchaser, register book is the sole source of information. So if you want to know anything, okay, you just go to the land office, you do a search, and then they're going to give you details of the register. So you don't need to look beyond the curtain, you don't need to go beyond behind it, right? So whatever in the register book is that is the information. And then under torrent system itself, upon registration, the name registered in the book will obtain an indefeasible title as provided under section 340 subsection 1 National Land Code. However, this indefeasible title is subject to exception under section 340 subsection 2. We're going to go into this later. Now, next one, we need to know, when we talk about land law, we need to know what does land mean. Right? Now, land has been defined under section 5 of the National Land Code. So, this is a very long definition. Okay, first one, the surface of the earth and all substance forming the earth, meaning everything, okay, on the surface of the earth. Secondly, the earth below the surface. Thirdly, all vegetation and other natural products, whether on or below the surface, like trees, what else? Trees, basically trees and other natural products, okay, and then the fourth one, all things attached to the earth or permanently fastened to anything attached to the earth, whether on or below the surface. Now, this is very vague definition. We're going to go into this section 5, subsection D in detail. And then last one, land covered by water. So this is what constitute land. So this is the definition. Now, the main part we're going to look into the section 5, subsection section 5, paragraph D, which is this part, not all things attached to the land, but the permanently fastened to anything attached to the earth, whether on or below the surface. So this is what we're going to do. Now, what does it mean then? Permanently fastened to anything attached to the earth. How do we determine? Now, it is very difficult to determine, right? Now, when you purchase a house, Is the air conditioner considered as land? Is the kitchen cabinet considered as land? What about lightings, etc.? Does it fall within this definition D? Does it fall within this D? Because, for example, let's say, can we just find a name? Okay, Mr. Ahmad, okay, when he wanted to buy a house from the vendor, he finds that there's air conditioner still installed. What else? Air conditioner, the fan, the lightings, right? So when Mr. Ahmad purchase, normally he will ask the owner, okay, the original owner of the land, when question like, do I get those air conditioner? Do I get all those kitchen cabinet? Now, this actually, when you need to actually ask the vendor when they sell the land to you, or when they sell the house to you, whether some of them wanted to take out the air conditioner. But for us, for our purpose, we need to understand whether those things, air conditioner, kitchen cabinet, lighting, fans, everything, is part of the land. Now, the answer is depends whether they are fixtures or chattel. Another name for chattels is fittings. So if someone were to talk about fittings, it also means chattel. So fixtures is something attached to the land, which is permanent. So when it's permanent, we call it land. But when it's chattel, it is removable, it's not part of the land. When it's not part of the land, it's not permanent, you don't need to consider that as part of the land. Okay. Now, there is a maxim, Latin maxim, which says that quid platanto solo sedit. It says whatever attached to the land belongs to the land. Now, in the case of Holland and Hodgson, the court stated that all things attached to the land are fixtures, thus shall form part of the land. So, when they form part of the land, when they form part of the land, they are what satisfy this, permanently fastened to anything attached to the earth. So when they satisfy this, they are within this definition of section 5, which is land. Land has these types of, these are all the types of land. Okay. Now, we look into fixtures. Fixtures means any chattel that has been annexed to the land, is fixed to the land, or building so as to become part of the land. Okay. Now, National Land Court is silent on the determination. So basically, it's so difficult because National Land Court did not define what is fixtures. So we look into the English law cases. Okay, this is what was decided in the case of Go Chong Hin and Consolidated Malay Rubber, where the NLC is silent on whether fixtures or anything that becomes part of the land are land. So we look into English cases. So there are two tests in order to determine whether it constitutes part of the land and whether it's a fixture or chattel. So we look first into degree of annexation. How far do you attach? How far do you annex those things to the land? And then after that, we look into purpose of annexation. Firstly, we look into degree of annexation. Okay. Now, degree of annexation, firstly, to what extent an item is affixed or attached to the land. If it's wrongly attached, it is a fixture. For example, machinery affixed with nuts and bolts. Okay. If it's resting by its own weight, it is a chattel. So, in case of Go Chong Hin and Consolidated Malay Rubber, in this case, it stated, okay, they decided that machinery which is affixed with nuts and bolts to the floor is a fixture. Okay. Now, when it's resting on its own weight, it is a chattel. For example, a picture nailed to the wall. You can take it out, correct? It's not actually annexed to the land or annexed to the wall. And then second one, to what extent an injury will be caused to the item upon its removal. So if you wanted to remove those items from that particular building, did you injure? Did you damage the wall, for example? Did you damage the floor, for example? Or do you damage the ceiling, for example? Now, look at the example. To remove a built-in cabinet will cause damage to it. So if you want to remove a kitchen cabinet, it will damage the floor, then it may be a fixture. If it damage the wall, it may be a fixture. Okay, now hence the stronger those item attached, okay, where is it now? Okay, the stronger those item attached or fixed, the more damage done to the item is removed, then it is a fixture. Or it can be the other way around. However, this degree of annexation test is insufficient. It's not conclusive. It can be rebutted by the second test. So you need to look into the next one, purpose of annexation. What is the intention of the person who annexed the item to the land? Now, if it's for the enhancement of the value of the land, it is a fixture. For example, statues, rock garden. Okay, but if it's a better use of the item as a chattel itself, not for the improvement, just for something, when you look at it, it's nice, just something to improve. Okay, so it is a chattel. For example, painting. So if based on the first test, the item is fixture, but if based on the second test, it is a chattel, the item remain a chattel. Okay, now look at case Go Chong Hin and Consolidated Malay Rubber. Okay, machinery affixed with nuts and bolts is fixture. Underground storage petroleum tank is a fixture. House built on stilts is a chattel. Still, this something is moving. And then a kitchen cabinet installed in a house affixed with nuts and bolts is a fixture. Thus, for example, when A sells the land to B, he also convey all fixtures attached to the land except for those which have been expressly excluded from the sale and purchase agreement. Remember, I gave you example just now? Okay, Encik Ahmad wanted to buy the house and then he saw the air condition. So if they wanted to remove the air conditioner, so if the air conditioner, when it's removed, it damaged the wall, it's a fixture. So basically, when Ahmad bought the house, it is to be together with that particular air conditioner because it's affixed to the wall, and if it's removed, it's damaged. However, if in the agreement itself, it's stated that those sale is without that particular agreement, that particular air conditioner, and Ahmad agree to it. So those items would not form as part of the land. Okay, you have to read the agreement. Now, those are all the general rules. So basically, all fixtures form part of the land. However, there are exceptions such as tenants fixtures. Okay. Tenant trade fixtures, item brought in and attached to the rented property, basically they are removable because they are just tenant. They're renting that place. Okay, they are still considered as chattel. Something like machinery, oven install, antique door, those are tenants fixtures. It should not form part of the land. Tenant's ornamental or domestic feature, for example, a tenant brought in antique door to his rented place. After the expiry, he can remove those antique doors. It doesn't belong to the landlord. Okay, and all tenants' agricultural fixtures. For example, chicken coop brought by the tenant into the rented land for agricultural purposes, even though it's erected and affixed with bolts and nuts. Why? Because they are tenant. Okay, they can remove it after the tenancy period. Normally, when people wanted to rent a place, they will explain the purpose of renting. Okay, so that is about fixtures and chattel.